Review by a higher tribunal, General Comment No. 32, 2007, Human Rights Committee. 45. Article 14, Paragraph 5 of the Covenant provides that anyone convicted of a crime shall have the right to have their conviction and sentence reviewed by a higher tribunal according to law. As the different language versions, crime, infraction, delito, show. The guarantee is not confined to the most serious offenses. The expression according to law in this provision is not intended to leave the very existence of the right of review to the discretion of the state's parties, since this right is recognized by the Covenant, and not merely by domestic law. The term according to law rather relates to the determination of the modalities by which the review by a higher tribunal is to be carried out, as well as which court is responsible for carrying out a review in accordance with the Covenant. Article 14. Paragraph 5 does not require states parties to provide for several instances of appeal. However, the reference to domestic law in this provision is to be interpreted to mean that if domestic law provides for further instances of appeal, the convicted person must have effective access to each of them. 46. Article 14, Paragraph 5 does not apply to procedures determining rights and obligations in a suit at law or any other procedure not being part of a criminal appeal process, such as constitutional motions. 47. Article 14. Paragraph 5 is violated not only if the decision by the court of first instance is final, but also where a conviction imposed by an appeal court or a court of final instance, following acquittal by a lower court, according to domestic law, cannot be reviewed by a higher court. Where the highest court of a country acts as first and only instance, the absence of any right to review by a higher tribunal is not offset by the fact of being tried by the supreme tribunal of the state party concerned. Rather, such a system is incompatible with the Covenant, unless the state party concerned has made a reservation to this effect. 48. The right to have one's conviction and sentence reviewed by a higher tribunal established under Article 14, Paragraph 5, imposes on the state party a duty to review substantively, both on the basis of sufficiency of the evidence and of the law, the conviction and sentence, such that the procedure allows for due consideration of the nature of the case. A review that is limited to the formal or legal aspects of the conviction without any consideration whatsoever of the facts is not sufficient under the Covenant. However, Article 14, Paragraph 5 does not require a full retrial or a hearing, as long as the tribunal carrying out the review can look at the factual dimensions of the case. Thus, for instance, where a higher instance court looks at the allegations against a convicted person in great detail, considers the evidence submitted at the trial and referred to in the appeal, and finds that there was sufficient incriminating evidence to justify a finding of guilt in the specific case, the Covenant is not violated. 49. The right to have one's conviction reviewed can only be exercised effectively if the convicted person is entitled to have access to a duly reasoned, written judgment of the trial court, and, at least in the court of first appeal where domestic law provides for several instances of appeal, also to other documents, such as trial transcripts, necessary to enjoy the effective exercise of the right to appeal. The effectiveness of this right is also impaired, and Article 14. Paragraph 5 violated if the review by the higher instance court is unduly delayed in violation of Paragraph 3, c, of the same provision. 50. A system of supervisory review that only applies to sentences whose execution has commenced does not meet the requirements of Article 14, Paragraph 5. Regardless of whether such review can be requested by the convicted person or is dependent on the discretionary power of a judge or prosecutor. 51. The right of appeal is of particular importance in death penalty cases. A denial of legal aid by the court reviewing the death sentence of an indigent convicted person constitutes not only a violation of Article 14, Paragraph 3, d, but at the same time also of Article 14, paragraph 5. As in such cases, the denial of legal aid for an appeal effectively precludes an effective review of the conviction and sentence by the higher instance court. The right to have one's conviction reviewed is also violated if defendants are not informed of the intention of their counsel not to put any arguments to the court, thereby depriving them of the opportunity to seek alternative representation, in order that their concerns may be ventilated at the appeal level.